Clerk, if you would sound the docket, please.
2020 DP 440 SCT Willie Corey Godbolt versus State of Mississippi.
You may be relieved of your duties should you choose. You all may be seated. Excuse me. And so what says the appellant?
We're ready, Your Honor.
All right, come forward.
Mr. Chief Justice, and may it please the Court. Greg Spohr with the State Public Defender's Office for Willie Corey Godbolt. I'd like to draw the Court's attention, specifically draw the Court's attention to the following claims. The admissibility of 404B evidence, spousal competency, the severance question, and fourth, time allowing, the constitutionality of Corey's on-scene confession. Under the label of motive, the state argues that evidence of Corey's prior assaults against his wife and daughter was admissible to show Corey's, quote, controlling nature of his wife and his family and his requirement of their obedience to him, in effect arguing that his controlling nature and prior instances of violence motivated him to commit the crimes in question. Now, quite simply, and through their own reasoning, the state sought to introduce other bad acts evidence to demonstrate that Corey acted in conformity therewith. Applied here, and per the state, Corey is a controlling nature and becomes violent when his wife and daughter do not heed his demands. Because his demand for his children was not met on the night in question, he acted in conformity with his controlling nature and his prior instances of violence. The state's admitted purpose for introducing evidence of Corey's prior acts fits squarely within the prohibitions of Rule 404. And further, the state fails to articulate the motive exception. They simply label it and move on. Now, consider the prejudice here. The introduction of 404B evidence raises an inference that because Corey acted violently in the past, he very likely acted violently again. Now,
Counselor, didn't he murder 8 people that night, then confess on a recorded statement to the media and also to law enforcement? Wasn't there testimony from people that drove him around while they were at gunpoint so that he could carry out the further crimes?
To the first part of your question, yes, Your Honor, 8 people were murdered. As to the confession at the scene, the confession...
Is it your argument that he did not commit these murders?
No, sir.
Okay, so if there's evidence that he committed these murders and you agree that he committed them, how could, even if this evidence was let in improperly under 404B, how could that be reversible in this situation? That's pretty overwhelming evidence of his guilt, even when you admit that he did commit.
Understood. Well, Your Honor, back to my point with respect to the prejudice, this inference depicted him as a violent person, a dangerous person, a person beyond rehabilitation, a person that commits violent acts.
Well, didn't he just murder 8 people? Those are violent acts, aren't they?
Yes, sir.
Okay, just go ahead.
Okay. And because Corey stood trial for crimes of violence, the introduction of prior acts of violence was particularly prejudicial. The inference could not have been far from the jurors' minds. And recall, the jury had lesser included options to consider. All this character evidence, all this propensity evidence, served only to arouse the emotions of the jury, served only to inflame the emotions.
From a timing standpoint, was the 404 prior acts established before these murders was established? Otherwise, I'm going to prove this a violent person. Oh, by the way, he committed 8 murders, or was he committed 8 murders? By the way, he's also showed a propensity. How did that time?
I believe it's the latter, Your Honor. Yes, sir. Again, all this character evidence, evidence of propensity, evidence of inclination, served only to arouse the jury, served only to inflame the jury's passions. placing a heavy thumb on the scale of a death sentence. Now, the state further argues that it was necessary to tell a coherent and rational story, that it was necessary to introduce evidence that Corey abused Sheena. Now, to the contrary, all this evidence tells us is that Corey has a propensity for violence, and that he acted in conformity in the night of the incident. It does not inform the other crimes. It does not tell the story of why Corey committed these crimes. Now, absent this evidence, the state's case would not have been confusing to the jury. There was ample other evidence to tell the story about Corey's strained relationship with his wife. There was other evidence to tell the story that Corey became upset when he could not have his children the night of the incident. This is simply not one of those cases so interconnected that mention of Corey's prior bad acts is necessary to tell the whole story. Now, what little probative value Corey's history of violence may have had, and without conceding it had any, but what little probative value it may have had was plainly and substantially outweighed by the danger of unfair prejudice. Now, of course, as this court is well aware, evidence of bad acts may be allowed in evidence, assuming the same passes the 403 balancing test, a balancing test that did not occur in this case. The trial court did not engage a balancing test, and that failure here weighs against the admissibility of this evidence and further supports the notion that this was indeed error. Shifting to spousal competency, which, of course, opened the door to the 404B evidence, the trial court permitted Sheena to testify under Rule 601. More specifically, subsection 601B3A and subsection B2. Taken in turn, 601B3A provides, in relevant part, if one spouse is a party, the other spouse may not testify unless both consent, except in a criminal case for a criminal act against a child. Now, Sheena, however, did not testify to the Coopertown Road scene where the only crimes against children occurred. She did not testify to the Coopertown Road scene because she had no direct personal knowledge of the events at the Coopertown Road scene. She must first satisfy the rule and have testimony to offer concerning a criminal act against a child.
Counselor, let me switch gears with you a second to the other part of that.
Yes, sir.
Obviously, the judge ruled on two separate grounds.
That's right.
One would be sufficient if it was sufficient. Would you agree with that?
I would.
This language in a controversy between them, how do you define that language?
Controversy between them, we see that as if I'm answering your question, we see that as a legal controversy, like a legal proceeding, as opposed to a factual dispute, a factual controversy.
How do you distinguish that from the Mabin case? Are you familiar with the Mabin case?
Vaguely, Your Honor, yes.
Which involved a crime by the defendant against the father of the spouse while the spouse was present, and she was allowed to testify.
Right.
As a controversy between them.
Because she was competent to testify. She was a witness to the crime against the child.
But you're switching over to the crime against the child. This dealt with the controversy between them.
I think that would afford her the same competency, the fact that she was a witness to the crime against the child. Yes, sir.
Okay. Well, there was no child involved in Mabin, but
well, I'm so sorry, Your Honor. Can you repeat the question once?
Yes, sir. In Mabin, the defendant committed an assault, I believe it was an assault, against the father of the wife.
Father of the wife, okay.
The wife was allowed to testify under the language of it being a controversy. Not under our rule, of course, but under the statutory language. And how do you distinguish that case from this one?
Well, she was not a victim in Mabin?
She was not a victim in the case that she was allowed to testify in. She was likewise assaulted.
And she was, and this was, I apologize for asking a question, but this was under 601B2?
So this was under the statute.
Under the statute.
The same language.
Right. 1315, I believe. Um, I'm thinking of Meeks v. State and Stevens v. State. But in both those instances, the wife was a victim to the crime. Distinguishing Maven is I'm not sure if Maven can be distinguished with respect to the controversies between them exception at this point, Your Honor. However, returning to 601B3A, again, Sheena must first satisfy the rule to have testimony, to offer concerning a criminal act against a child. The rule requires Sheena to testify to only what the rule allows. Now, to that end, Mississippi Rule of Evidence 601, read in conjunction with Mississippi Rule of Evidence 602, which provides that a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. Because Sheena was not competent to testify to a crime against a child, she failed to satisfy the purpose of the very exception under which she was allowed to testify. Now, with Maven in mind, the rule further provides that one spouse is competent to testify against the other in controversies between them. The state argues that because Sheena was a victim of Corey's crime spree, that she was competent to testify. However, she was not a named victim. The state did not allege a crime wherein she was a victim. The controversies between them exception, as I noted a moment ago, is a legal controversy, a legal proceeding, not a factual controversy, not a factual dispute. The state, indeed, Black's Law Dictionary defines controversy as a litigated question, an adversary proceeding in a court of law. Now, the state asks too much and would broadly apply the controversies between them exception to any case where a spouse endured some degree of loss, some degree of mental anguish. Shifting to the severance question. Pre-trial, Corey moved the trial court to sever the 12 counts and hold trials for counts 1 through 6, the Lee Drive charges, counts 7 through 10, the Coopertown Road charges, and counts 11 and 12, the East Lincoln Road charges. To this end, this court considered the Corley v. State factors. 1, whether the time between occurrences was insignificant. 2, whether the evidence proving each count would be admissible to prove the other counts. And 3, whether the scenes, the transactions are interwoven, whether they constitute a plan or a scheme. Now, where the facts establishing these factors are not present, there can be no common plan. There can be no scheme to justify a multi-count indictment. In Corley v. State, this court articulated a reluctance, an unwillingness to try separate and distinct offenses in the same criminal proceeding, holding, we do so in order to avoid potential problems of a jury finding a defendant guilty on one unproven count due to proof of guilt on another, or convicting a defendant based upon the weight of the charged offense or upon the cumulative effect of the evidence. Now, to this end, consider the prejudice of trying 12 counts in the same criminal proceeding. The jury heard evidence of murder and violence against separate victims at separate scenes, separated by hours, and absent overlapping evidence to establish a link, a tie between the three scenes. Separate trials would have cured this. Separate trials would have tempered the degree of violence heard here. Now, by example, at a trial for counts 7 through 10,
Is
evidence...
that a
of-
standard to temper the degree of violence that a jury hears?
No, sir, but
Didn't the judge just find that this was a spree, a common scheme or plan? I mean, this was a shooting spree that occurred over a couple of hours where he went from house to house to house killing these people. Do you really think it would have been more appropriate to have 3 separate trials for the different murders that occurred right here, and then he points a gun at some other folks, has them drive to the next house, let's have a new trial on this other one? Just, it's a common sense discretionary decision on the trial judge's part, isn't it?
well,
I mean, how can we overturn it as appellate judges when we're looking at his ruling?
it's certainly an abuse of discretion standard, absolutely, Your Honor. However, and I'll get to this when we discuss the second Corley factor, whether the evidence proving each count would be admissible to prove other counts. And if I could have just an inch of latitude prior to getting to
Go ahead.
that second Corley factor. Thank you, Your Honor. Again, with respect to the prejudice, at a trial for counts 7 through 10, evidence of a slain police officer would not have been heard. At a trial for counts 11 and 12, evidence of multiple kidnappings and 3 capital murders would not have been heard. Evidence of 2 slain juveniles would not have been heard at a trial for counts 1 through 6. The murders at scene 1 in no way informed the murders at scenes 2 or 3. The murder of Deputy Durr, capital murder of Deputy Durr at the first scene, was not a means to accomplish the capital murders of Austin Edwards, Jordan Blackwell, or Sheila Burris. The crimes do not prove a relationship between the scenes. And at sentencing, the jury heard evidence of statutory aggravators applicable to some counts, but not to others. At separate trials for counts 7 through 10, the jury would not have heard allegations that Corey allegedly stalked Sheila Burridge prior to her death. The jury would not have heard that Deputy Durr was clutching his wedding ring as he lay dying. Further, in absent severance, the jury heard emotionally charged victim impact evidence. In a trial for counts 7 through 10, the jury would not have heard, Your Honor.
I was just going to say, so the jury would not have heard, if there were separate trials, the consistent truth of what happened that night on the shooting spree.
No, Your Honor. There are, simply because it may have been, or it may be challenging to try these cases, try these counts rather, as separate standalone cases, I don't believe is a reason not to sever, Your Honor. In the trial for counts 7 through 10, the jury would not have heard the victim impact evidence of children singing along with Deputy Durr's ventriloquism act.
So under your logic, the people that were impacted by these crimes would have to go to 3 or 4 trials to say the same thing?
Well, not necessarily the same thing. There would be
And what about the witnesses? Would they have to show up at 3 or 4 trials? All the things that...
Well, the witnesses are different from scene to scene, Your Honor. So there wouldn't be that. There is no overlap with the witnesses. The witnesses are different. The investigations are different. The subject matter is different.
And that's not within a court's discretion to make those decisions?
It's within the trial court's...
Trial courts.
It's within the trial court's
So
discretion.
we have to find that he abused his discretion?
That indeed is the standard, yes, sir.
And that's what you're asking us to do?
Yes, sir.
Okay.
Relatedly, in a trial for counts 1 through 6, the jury would not have heard evidence of 11-year-old Austin Edwards' diligent study of his Sunday school lessons or Jordan Blackwell's excited anticipation to play college football. Finally, and had the counts been severed, 404B evidence would likely not have come into evidence, removing that label of violent, removing that label of dangerous. Now, with respect to the first Corley factor, whether the time between occurrences is insignificant...
I want to get that straight. You're saying that 1 or 2 or 3 of the crimes were not violent?
No, sir, they were all violent.
You're just saying that multiplicity of violence.
No. I was the label of violence, the label of dangerous would have been removed with respect to his prior acts of violence.
We'll get back to your first conversation about 404 prior bad acts. So
Yes, sir.
part of the other crimes wouldn't go into the second trial or the third trial? So on that very night, he had a prior bad act?
Well, again, these are different scenes. These are different witnesses. There's really no evidentiary overlap to justify a single trial, all 12 counts in a single trial, given the lack of evidentiary overlap. And if I could just jump to the second
Please do,
factor.
I'm sorry.
No.
But counsel, wasn't there also evidence that he was asked to stop or asked to turn himself in, and he chose not to? He chose to continue. Would that evidence not have come in these separate trials that you ponder?
It may have come in with respect to when he said that. It may have come in with respect to a particular scene. If it was, say, between scene 1 and 2, it would likely come.
Let me interrupt you for a second. I see your light went up.
Oh,
but
yes.
the court wants you to have the opportunity to make your argument. So
Yes,
if
sir.
you want to use additional time, you may.
Well,
We've had a lot of questions. You may not have said everything you want to say.
okay, yeah. Well, to answer your question, can you repeat once again? I'm so sorry.
Well, I mean, there was evidence that along the way,
Right.
he had friends or family members encourage him to stop and turn himself in, which is evidence of the common scheme, plan, and the course of action. So you're saying that evidence would not have come in the other cases?
No, that's indeed what I'm saying. There could have been, there could be rather evidentiary stipulations, factual stipulations. However, in 3 separate trials. However, no, yes, they're, to answer your question, yes. I'll stick to yes on to your question, Your Honor. And I see that I'm out of time, Your Honor.
Chief, I would like
Sure.
to delve into something that you did not mention today in your argument, but that you mentioned in your brief, and that are you submitting to this court that when the underlying crime involves domestic violence, that any prospective juror with any sort of past experience with domestic violence should automatically be disqualified from the jury?
No, ma'am. We're not saying that like a lone juror simply has an association with domestic violence should be struck automatically. We're not saying that at all.
Okay. And so what is your complaint with the jury with regard to victims of domestic violence having served?
There were, I believe, of the 45 members in the Venire, 6 or 7 jurors with potentially disqualifying associations with domestic violence. And given that number and coupled with other, what we've labeled as moon violations, factual situations wherein the jury is disproportionately comprised of potentially disqualifying jurors.
Can we look at a few of those? Juror number 1, stepdaughter and cousin were victims of domestic violence, but Mr. Godbolt, he didn't object to that witness for cause, that juror for cause, did he?
For that particular juror, I do not believe he did, because again, Your Honor, a lone juror with domestic violence experience he or she is not per se excludable.
Okay. And so with regard to the jury that actually decided this verdict, is there one in particular that you're saying should not have served on that jury?
Absolutely. There are a number we're saying that should not have served on the jury.
Who did Godbolt object to that for cause that the court that still served on the jury? If they objected for cause because juror number 5 was a victim of domestic violence, but you did not object for cause on that one. Juror number 6 was had a protective order for a stalker. That one was not objected to for cause.
Yes, ma'am. Well, again, a lone juror with domestic violence associations is not per se excludable. The concern was that the jury was disproportionately comprised with potential jurors with associations to domestic violence. So the challenges came in the peremptory challenges.
How could you be heard you did not challenge these for peremptory, and you did not challenge these for cause.
Yes, ma'am.
Isn't that correct?
I believe that's correct.
So why should we hear a complaint today about that?
Well, I think the greater complaint with respect to the jury is the Moon violation concerning law enforcement and the percentage of statistical aberration that came of the 45 Venire members. Over 30% of the Venire had associations with law enforcement. Now that associated with individuals that had domestic violence experience further frustrated qualifying a jury.
I don't have any further questions.
Thank you.
What's the state?
We're ready to proceed.
Mr. Chief Justice, and may it please the court. My name is Allison Hartman. I represent the state of Mississippi on behalf of Attorney General Lynn Fitch. This court should affirm Godbolt's 4 capital murder, 4 first-degree murder, 1 attempted first-degree murder, 2 kidnapping, and 1 armed robbery convictions, and his resulting sentences, including 4 death sentences, because no errors were committed in the trial court. Godbolt has raised a number of issues, all of which lack merit, and I'd like to start with the severance issue and then kind of work in reverse. The trial court correctly applied the standard delineated by this court in Corley when it denied Godbolt's motion to sever. It held the required Corley hearing, it considered the 3 Corley factors, and then it correctly applied those factors when it denied Godbolt's motion to sever. I think a lot of the interest and concern from opposing counsel and your honors was on the 3rd factor, which was the interwoven factor. And this court is focused on whether or not there is a common thread between all of the crimes when deciding whether a trial court has abused its discretion in denying a motion to sever. Here, the common thread was clear. It was Sheena, and it was the fact that she would not let Godbolt take his kids that night when he demanded that she let him take the kids. We knew that that was his plan because Bubble testified at trial that he told her that very day that he would rather die or kill before he let anybody else take his kids. He was also watching videos on YouTube that day about loading and unloading AR-15s. He had AR-15s, and they were on his bed while he was watching these videos. Also, when he showed up to that first crime scene, he said he was there to take his kids, and the family would not let him take the kids, and that's when he enacted his plan to die or kill before he let anyone keep the kids. So I think the common thread here is pretty clear, and all of the acts he committed that night were in furtherance of that plan because Sheena took the kids, busted out a window in the back of the house, and then ran through the woods barefoot in the middle of the night to escape him. After he killed 4 individuals, including a Lincoln County deputy at that scene, he kidnapped a neighbor who drove him to the next crime scene where he murdered a child and another young man. And then he kidnapped another young boy who drove him to the next murder scene to murder 2 of Sheena's cousins. So all of these crimes are inherently related, and there is no way to separate them. And that's what the trial court held when it denied Godbolt's motion to sever. It held that these were virtually a single transaction, and the trial court was right in holding that. And also the other 2 factors also weighed against severance, the time factor, whether or not the time between the crimes was significant, and here it wasn't. It was about 5 to 7 hours. And this court has held in Patrick and Golden that a 7-hour lapse in time is not significant under Corley. And also, the overlapping evidence in this case. Godbolt has focused a lot on the evidence that does not overlap, but this court has held that when some of the evidence overlaps, that weighs in favor of not severing the charges. For example, in Golden, the defendant was charged with raping 2 different women, and some of the evidence, not all of the evidence, would be admissible to prove both of those rapes. And this court held that because some, not all, of the evidence was overlapping, that severance, the trial court did not abuse its discretion by refusing to sever the charges. And here there's also a significant overlap in evidence from all 12 of Godbolt's charges. Just for example, a lot of the ballistic and firearm evidence would be admissible to prove all 8 murders. He used the same guns in each of the murders, which the state's ballistic expert testified to in regards to each of the 8 murder charges. So the ballistic evidence recovered from the victims' bodies, as well as the evidence recovered from the crime scenes, would be admissible to prove all 8 murders, as well as the actual firearms themselves. And relatedly, the testimony from the pawn shop owner who sold Godbolt these weapons would be admissible for all 8 charges, because he testified that these were the guns that he sold to Godbolt, and then the ballistic expert testified that those were the guns that Godbolt used to murder 8 individuals. Additionally, one of the kidnapping victims' testimony, LaPetra Stafford, she testified that when Godbolt showed up to her door that night, he admitted that he had just killed Deputy Durr and Brenda May. He then kidnapped her, held her at gunpoint, and made her drive him to Coopertown Road, where she saw him begin to shoot his AR-15 into the house full of children. So her testimony was overlapping for at least 4 murders, her own kidnapping, and then Xavier Lilly, the second kidnapping victim's testimony, was admissible, obviously, for his own kidnapping, but then he also had to witness the murder of 2 of his friends. So his testimony was admissible for the murders, for his kidnapping, and then he actually dropped Godbolt off at the 3rd murder scene, which was the barrage home. So it was admissible for purposes of that 3rd murder scene as well. So the significant overlap in evidence, the insignificant time that elapsed between the crimes, and then the fact that there was a common thread and that the crimes were inherently interwoven, means that the court did not abuse its discretion in denying Godbolt's motion to sever. Next, I'd like to focus on Sheena Godbolt's testimony at trial. The trial court correctly held that Sheena was competent to testify against Godbolt at his trial. She was competent to testify under 601B3A because there was a child victim in this case, and also under 601B2 because Sheena was a victim of Godbolt's crime spree that night. Godbolt has attempted to limit 601B3A to only allowing a spouse to testify about the crime that involved the child, but that's not the language that 601B3 says. It permits a person to testify against his or her spouse in a criminal case for a criminal act against a child. And here, Austin Edwards was 11 years old when he was murdered. And we also have to look at this going back to the 3rd Corley factor, which was the fact that there was a common plan or scheme that made these crimes so inherently interwoven that they were virtually a single transaction. Because there was a child victim and because this was essentially one crime spree, the fact that there was a child victim opened the door for Sheena to testify against Godbolt in the whole in this trial. And the trial court did not abuse its discretion in holding that Sheena was competent under the child victim exception to Rule 601. Additionally, Sheena was a victim of Godbolt's crime spree. As your honors noted, this exception really falls under the controversies between them exception to Rule 601. And in Meeks, this court carved out an additional exception. I'm sorry. Oh, I'm sorry. This court carved out an additional exception for where the spouse is a victim of the crime spree. So this court read an exception into the rules exception itself, and the court has never limited that to a spouse being a victim named in an indictment or to have had a crime directly committed against the spouse herself. So I think it's important to look at the Black's Law Dictionary of what a victim is. And that's a person harmed by a crime, tort, or other wrong. And here, there's just not a reasonable argument that Sheena was not a victim of Godbolt's crime spree that night. The whole reason that he was there not that night and ended up murdering 8 people was because he was there to take the kids from Sheena. And he murdered Sheena's aunt, mom, sister, 2 cousins, her best friend's son. So she was definitely a victim of his crimes in the sense that she suffered emotional and mental anguish and trauma as a result of Godbolt's crime spree. So I think it would be reasonable for this court to hold that under the exception it created in Meeks, that Sheena does meet that definition of a victim, so that the trial court correctly admitted her testimony and held she was competent to testify against Godbolt here. Turning to the prior bad act evidence, the trial court did not abuse its discretion by allowing Sheena and Bubble to testify about Godbolt's prior violent acts against Sheena. Yes, the fact that he was violent towards Sheena in the past may have showed a propensity for him to be violent in this case, but it also showed motive in this case. And in Johnson, this court held that prior evidence of domestic violence, even though it may also show conformity with the prior violent acts, as long as it also shows motive, then it's admissible under Rule 404B. And even in his pro se brief that he filed, Godbolt admitted that he was there that night because Sheena ultimately made the decision opposed to his unequivocal stance that he take the kids back to his home that night. So the evidence that when Sheena in the past failed to comply with his demands to change her shirt or to give him her cell phone and he was abusive, that shows that his motive here was to punish her. But even if this court were inclined to hold that this evidence should not have been admitted, the prior bad act evidence should not have been admitted, it was harmless error. There was significant evidence of Godbolt's motive and intent that night, even if you exclude the prior bad act evidence. For example, Bubbles' testimony again about Godbolt watching videos about how to unload and load his guns the day of the murders. Her testimony that he had his guns out on his bed that night, and his statement that he would rather kill or be killed before he let the kids stay with anybody else is evidence of his motive. Also, when he was arrested, and this is in Teresa Pell's video that was introduced into evidence, Godbolt says that Deputy Durr was not part of his plan and that he just got in the way. So Godbolt himself admitted that he had a plan that night, and judging by the other evidence that was introduced, that plan was to get his kids, and he would rather die or be killed than let his kids go with anybody else. I'd also like to address the admissibility of Godbolt's confession. Independent crime reporter Teresa Pell was on scene when Godbolt was arrested. She recorded his arrest, and she asked him a few questions as he was being arrested. Godbolt turns this claim into one of wanting to know who Miss Appel's source was and why she knew to go to the crime scene that night. But that's irrelevant, because under oath, Miss Appel testified that law enforcement or anyone related to law enforcement did not tell her to go to the crime scene or to the arrest scene. No one told her to ask any questions. No one gave her any access, special access to the crime scene, and no one directed her to do anything. So there's no way that Miss Appel could be considered a state actor when she was acting on her own as an independent crime reporter and doing her own job to break news to the public, and she was not doing law enforcement's job. So her source is just simply irrelevant. Just because Godbolt wants to know who told her about it doesn't mean that her recorded video is inadmissible at trial, and the trial court properly admitted that video at trial. And I know Justice Beam asked some questions about the domestic violence, the members of the Venire who had experience with domestic violence. And you're right that Godbolt did not raise this issue at trial, so it was raised. He didn't challenge any of the jurors with potential domestic violence experience. He did not raise this issue in any way before the trial court, so it's waived. But even so, the jury was not disproportionately comprised of any individuals who had domestic violence experience. Only 6 of the jurors who were subjected to individual voir dire had any experience with domestic violence, ranging from personal experience to indirect experience to knowing someone who had experienced domestic violence in the past. And all of those jurors during voir dire said that they could set any of those experiences aside and judge Godbolt based on the evidence that was presented and not based on any biases that they could potentially theoretically have based on prior domestic violence experience. And the same goes for potential jurors with law enforcement experience. In Evans, this court held that when a trial court conducts extensive voir dire and questions jurors about their ability to set aside any relationships or experiences they have, then that cures any potential biases that those jurors may have based on their law enforcement experience. And here there were, I think, 11 potential jurors who were related by blood or marriage to law enforcement officials. All of those readily confirmed that they could set those relationships aside and judge Godbolt fairly and impartially, and that they would only judge him based on the evidence. So the trial court correctly conducted voir dire in this case. The jury that was seated was fair and impartial, and there's no issue here. And the trial court's handling of voir dire should be affirmed by this court. If your honors don't have any questions about any of the other issues, then the state would rest on its briefs in these arguments and ask the court to affirm Godbolt's convictions and sentences in this case. Thank you, Your Honor.
May it please the court. From the outset, and I've been thinking deeply about this, but Mabin v. State, revisiting that, trying to reconcile the case with Meeks v. State and Stevens v. State, and I simply can't. So I would submit that Mabin was wrongly decided. If I could, I think starting with the first Corley factor may be a good place to start, because the state is really focused on, with respect to the length of time, the state is really focused on a number, 7 hours, I believe it was in both Gold and in Patrick, as it was roughly here. It's not the length of the time necessarily, it's the quality of the time, and in this instance, an utter lack of evidence of a master plan. As Justice Beam noted in Lomax v. State, there is no bright line test with regard to the time factor, and trial courts are instructed to consider the totality of the events surrounding each case. And that's an assessment that the trial court failed to make here. And consider these lapses in time. Following the crimes, at the first scene, Corey and Miss Stafford drove for hours. They embarked on a hours-long rambling drive throughout Pike and Lincoln counties, changed direction of travel 11 times, stopped or contemplated stopping at 7 different locations. A plan or a scheme assumes deliberation. It assumes aim, not aimless travel. Relatedly, in following the crimes at scene 2, Corey and Xavier Lilly drove for hours. They stopped at a gas station in Macomb. They stopped at 3 separate residences in Bogachita. They stopped to eat. They stopped to use the bathroom. They then drove across South Mississippi as far as likely Harperville before finally reaching scene 3, which is mere minutes from scene 2. Now, with regard to the second Corley factor, whether the evidence proving each count would be admissible to prove the other counts, and again, the trial court found that it would be virtually impossible to try these counts as standalone cases. But much of the evidence presented was indeed different. The evidence needed to prove one scene was different than the evidence needed to prove the other scenes. Consider just some of the uncommon evidence from scene to scene. Blood evidence and the way the bodies were positioned at one scene in no way informed other similar evidence. The crime scene investigations were different. They varied from scene to scene. Video evidence and audio recordings concerning one scene but not others was without question prejudicial given the emotion and the tenor behind such evidence. Autopsy findings.
You mentioned similar scenes. You're saying there's a lack of similarity between the scenes?
Yes, sir. Yes, sir. Much of the evidence needed to prove one scene was not necessary to prove the other scenes.
And when you're talking about similarity, was every victim the victim of multiple gunshot wounds? You pointed out 11 times this, 7 times that,
Yes, sir.
3 times this. Was each victim a victim of multiple gunshot wounds?
Yes, sir. I believe so.
And the fact is, the record reflects that Deputy Durr was shot 3 times.
Yes, sir.
Brenda May was shot 5 times. Torquera May was shot 9 times. Barbara Mitchell was shot 8 times. JB was shot 4 times. AE was shot 4 times. Farrell Burridge was shot 12 times. And Sheila was shot 2 times.
Yes, sir.
So you're saying the court, considering that evidence along with everything else, there's still a lack of similarity.
Yes, sir.
That these multiple gunshot wound cases is, I've been on this court almost 20 years.
Yes, sir.
I don't know that I've ever seen this many victims with this many people shot this many times, ever.
Yes, sir.
But do you have any cases that supports that should not be considered by a trial judge?
Well, Your Honor, a couple of things. The fact that the crimes, the way they were committed, were similar from scene to scene to scene, is not enough of a connection, not enough of a. It's not a factor or a controlling factor under Corley, right? There needs to be more of a connection. Simply
Would they
because
have to be shot 24 times instead of 12? When you say a lack of similarity, what are you saying is the first consideration under Corley?
the first consideration, with respect to the time,
No. Case law, Corley.
Yes.
What are the considerations that a trial judge should undertake?
the considerations include whether the time between occurrences is insignificant, the first. And I should note that that's a prerequisite to 2 and 3. The second, whether the evidence proving each count would be admissible to prove the other counts. And the third, whether the crimes or scenes in this instance are interwoven, whether they constitute a common plan or scheme. And then,
Mr. Spoor, were not all 3 of these scenes connected by the fact that they were occupied by people who were familiar with Mr. Godbolt and his estranged wife and their marriage?
and again, to that, Your Honor, I would say that is not enough of a connection, that is not a factor under Corley.
Given that these murders began when Mr. Godbolt was at his in-laws' house, frustrated that they would not let him get his children, and then later, at some point in the evening, did he not say something to the effect of he was tired of people meddling in his marriage? I fail to see how that's not a common thread that ties all of this together.
Sheena, his wife, being the common thread?
The fact that he was frustrated by not getting his children from the very beginning, that he was complaining about people meddling in his marriage, and that each one of these scenes was selected by him, the evidence seems to show, because of the connection to either him or his wife or their family.
Well,
That seems to be a pretty strong common thread to me.
understandable, but consider scene 2, where Corey's focus, which is evidenced by text messages that he sent to her. Corey's focus was on Tiffany Blackwell, not Sheena.
Why was his focus on Tiffany Blackwell?
Revenge.
Revenge for?
Given the meddling, given
So
her
there's the
interference.
common thread, right? I mean,
It's just, it's by itself alone, it's just not enough under Corley. There needs to be more of a connection to establish, because that fact alone doesn't downplay the significance of the time between occurrences in any way. Again, from scene to scene, much of the evidence proving each count was not admissible to prove the other counts. With respect to the third Corley factor, and is evidenced by the significance of the gaps in time and the lack of evidentiary overlap, the scenes here were simply not sufficiently interwoven to constitute a common plan or scheme. The Lee Drive charges, where Corey went to protect his children and not harm Sheena, as the state alleges, involved different victims, involved different witnesses, involved different investigations, involved different subject matter, and were committed hours before the Coopertown Road.
Were the same guns used in all these crimes?
Yes, sir.
Same trigger on all those guns in all these crimes?
Yes, sir. No, that's correct. But the state, with respect to evidentiary overlap, their mention amounts to the guns were the same. Now, the guns being the same is, again, simply not enough of a connection to tie these cases together. There needs to be more. And here, again, there were different victims, different investigations, different witnesses, different subject matter, and they were committed hours apart from scene to scene.
By the same shooter?
Yes, sir. But there is case law to support the idea that simply because the perpetrator is the same across all three scenes is not enough of a connection.
Wouldn't they all be interconnected, though, Counselor? I mean, you said that he came there to make sure his children were protected. The deputy was there. You had a law enforcement officer assuring the children's safety, telling him to not go away and don't ever come back. Go away and come back in the morning and get the children.
Yes, sir.
Is my understanding is what the officer told him.
Yes, sir.
That's when he murders the officer, and at that point, he knew he was gone, and it was to settle all scores with his family. I mean, in effect, he basically became like a shark on a feeding frenzy. He tasted blood, and he went from house to house to house. Everyone was interconnected. He went to one place to kidnap a woman and to get a transportation to the next crime scene. How could that all not be interwoven?
I would contest the kidnapping being evidentiary overlap. The kidnapping, I believe, informs the counts previous, not the subsequent counts, because how do you account for all this time? All this is 11 changes of direction, 7 stops, different stops. How do you account for that? I mean, if indeed he's using these kidnapping victims as transportation from scene to scene, how can you explain when scene 2 or 3 are just minutes apart? It took him hours to get from scene 2 to scene 3.
Obviously, his state of mind was not one of great clarity,
Yes,
other than focusing on destroying these people.
yes, sir. Now, back to the Lee Drive charges, where Corey, again, went to protect his children, not hurt Sheena, as the state alleges. Again, the Lee Drive charges involve different victims, different witnesses, different subject matter, different investigations were committed hours before Coopertown Road, where, as I just mentioned, Corey's focus was on Tiffany Blackwell and not Sheena. Now, the East Lincoln Road charges further involved different investigations, different witnesses, different subject matter, and occurred hours later at a different scene. And it was absent, East Lincoln Road was absent a plan, much less a master plan. And several of the reasons listed under Mississippi Rule of Evidence 403 as justifications for prohibiting certain information certainly apply here. The jury's reliance on an unbroken presentation of testimony, of photographs, of recordings, of detailing murder, detailing violence was without question, without doubt, prejudicial. And despite the sheer volume of evidence, the trial court failed to conduct a 403 balancing test here. And that failure, given the nature, given the volume of the evidence, that failure to conduct a 403 balancing test just further highlights the error within this claim. Turning to I believe the state brought up the Therese Appel, the Clarion Ledger crime reporter. Now, the trial court's refusal to require Therese Appel, the crime reporter, to answer questions about who exactly informed her of the incident matter, who exactly called her that morning, and to whom she was text messaging en route to the scene, that is the critical point of this issue. We do not know, absent an answer to that question, we cannot know if the state is responsible overtly or covertly for Appel's conduct. Corey was entitled to a full disclosure of the facts, not a speculative presentation, not a partial disclosure, and that's what we have as it stands. We have a partial and speculative presentation of the facts. The allowance of the First Amendment objection here to withheld evidence that is plainly relevant, and that withholding cut deeply into the ties of due process. Denying Corey access to the caller's identity frustrates a proper determination on the admissibility of Corey's on-scene confession. Now, the state cannot use the First Amendment as an excuse to withhold demonstrably relevant evidence that likely shows that Appel did indeed speak to law enforcement that morning. And consider the circumstances. She received the phone call 90 minutes prior to arrest. She arrived on scene in the immediate wake of his arrest, prior to the scene even being secured. She was afforded intimate access, unusual access to Corey at a multi-count homicide-related crime scene, and she was eliciting information, incriminating information from him in the presence of law enforcement. Now, state action exists where there is a sufficient nexus and or a close connection between the state and the conduct of the actor. A determination of close connection is made by weighing the circumstances. And this was established, this close connection, this sufficient nexus was established almost immediately, even, I would argue, even before the phone call, given that Therese Appel was once a crime reporter in Brookhaven and knew most, if not all, of the police officers in the area, including Deputy Durr. Now, at the suppression hearing, the state was very clever in its questioning of Appel, never directly asking if someone from law enforcement called her, never pointedly asking that question. Instead asking, did someone from law enforcement direct you to do something? And she, of course, answered, no one directed me to the scene, and defense counsel was precluded from fleshing out what indeed directed.
Well, if that was a truthful answer.
Your Honor?
You say prevented from fleshing out. If it was a truthful answer, what is there to flesh out?
Well, given the circumstances, Your Honor, questioning her, the veracity is necessary. Given that we're allowing the First Amendment to trump due process, we're allowing the First Amendment to trump the Fifth and Sixth Amendment, she needs to answer that question. Who called her? Who informed her of this?
So a lot of reporters just have, well, they have those radios in their car. They're listening. to police communication.
Right, but she informed the court that someone called her, someone contacted her on the phone and informed her of the events.
And you're saying that Godbolt had the right to know who that person was?
Indeed, yes, Your Honor.
And the First Amendment right of the reporter should be disregarded.
Yes, sir. And they can't use it as an excuse to withhold relevant evidence, is our point, Your Honor. I see that I am
Let me ask you a
over.
question. Assuming for the sake of arguendo that somebody from law enforcement, J. Edgar Hoover, calls her, but doesn't direct her to do anything, there's no problem, is there?
I would not, I mean, whatever information she received, she acted on it, and that brought her to the scene.
But there's no directive. If the sheriff says, hey, there's a bank robbery going on down here, he's advised somebody that something's happened.
That's right.
He hasn't said, hey, we'd also like you to go down there and surreptitiously walk through the scene, stand there with a recording device, and record the defendant. I think it's a pretty big stretch, even assuming this arguendo here, that a law enforcement person made initial contact.
That's
You would
right.
have to assume that they had directed her to then get in your car. Now you come down here. Now get your phone, get near him, video him. I mean, those are a lot of steps that there's absolutely no evidence to show.
Well, there is evidence, in fact, Your Honor. There's the circumstances.
Did anybody testify to that?
Your Honor?
Did anybody testify to that?
There was testimony from, I believe at the pretrial hearing, the suppression hearing, there was testimony about how close she got to the police, when she arrived, when she received the phone call, that she was a crime reporter in Brookhaven, that she knew most, if not all, the
But
police.
no testimony that anybody directed her to do anything.
Your Honor?
That there was no testimony that anybody directed her to do anything.
No, because the court precluded that question. The court prohibited her from answering that question.
Yeah, but there's no testimony from anybody else. The sheriff didn't say, hey, look, I told her to go do this. That was just a big assumption.
Well,
I mean, can't a reporter find out that something's happening and show up at the scene? Doesn't that happen every day in America?
Indeed, Your Honor, but here she receives a phone call and acts on it with information that
Like
only law
reporters do
enforcement
when they
would
get
know.
phone calls about something going on?
Sir?
Like reporters do when they get phone calls that there is something going on down here at the bank or something big has happened down here in Brookhaven.
Right. Again, given what she knew, given the circumstances surrounding the phone call, it seems clear that law enforcement contacted her. Who would be privy to this information at this hour other than law enforcement? I mean, the circumstances are fairly clear in my mind that she spoke to someone from law enforcement.
What's the basis of it being clear in your mind?
Again, the circumstances I've just mentioned, Your Honor.
I don't mess with electronics much, but I know people listen to these things on a regular basis, don't they?
To
Police communications.
scanners?
If I recall, you said this thing lasted 5 to 7 hours.
Yes, sir.
Was it being reported by any news that there was an ongoing problem in Brookhaven?
Yeah, she was the first on the
Pardon?
scene. She broke the story.
I know she wrote the first article. Was there any communications?
Not that I'm aware of, other than I believe Appel broke the story, and she first brought it to the public. And again, the trial court insulated Appel from critical questions that the suppression issue could never evolve absent answers to these questions.
That your argument had, should that confession that she made to him not got in evidence that he would have been otherwise acquitted? That that's what caused this convictions or convictions?
Well, I mean, the prejudice here is the fact that he confessed, right? And she captured it on her phone.
He
That's what-
confessed to other people that testified, didn't he?
Sir?
He confessed to other people in conversations that night who testified, did he not?
No, he did not testify.
He didn't say, I messed up. I don't think that's the words he used. This is duck. I messed up.
Right, there's no explicit confession during,
He told one of the drivers he shot the policeman or something, did he?
yes, I believe that may be true, Your Honor. But much of the discussions concerned what was motivating him to go from scene to scene, and had less to do with confession. And I think there was more innuendo in a lot of the text messages that he was sending that could be explained as much.
All right, your time has expired.
Yes,
If you
sir.
got something critical that you didn't get done, I'll grant
Thank
you
you.
time. All right. The court, I'll allow you to be seated. The court appreciates y'all's effort today. We will take this case under advisement and render a decision in due course.